Can you hear me?
How are you, Kim?
I'm good. How are you? Can you hear me okay?
Yep.
Okay.
Lance probably can too. Oh, there he is.
Oh, he was there.
Yeah, I was
Okay.
unmuting myself. I had all I could see was a stupid still photo of myself, and it was annoying. Anyways,
Okay.
Hi, Kim.
Hello. Now what did I do? Oh my goodness. Go back.
The learning curve.
Oh, well, that's
not a learning
exactly.
curve. It's a line kind of like that. You get to the top and you fall off.
Okay.
I was doing a workplace investigation. I was trying to set up an interview with one person and their union rep, and oh my God. Anyway.
Yeah, I hear you. So, oh, I need to put the chat up to the side more. Where is that thing for people?
How many people have you got, Kim?
I think about 30. Now I've lost that window.
Wow.
Yeah.
Wow.
But I've got it on Eventbrite and then some are on the other, so I'm not really sure. And if some people have registered twice, so we'll figure it out.
Yeah.
So you have slides? Do you have slides?
Lance. Or I do too. I've got them too, either way.
So
I can share my screen. Hold on. Let me try sharing my screen and see if.
Okay.
That's what I thought we could try and do before this
Okay,
all
I'm not
started.
allowed to because it's disabled by the host.
Okay, just a sec. Oh. How do I go back and do the advanced files? Oh, wait a second. Do I have to make you a host? More. See. Stop share. Okay.
I think it's down in that little share screen.
Okay, multiple there. I keep forgetting about these little arrows. So you should be able to share your screen now.
Okay, and let's have a look. What are you seeing?
Your slide.
Yeah,
that's great.
That is fantastic.
Woohoo! Now will it move forward and backwards? All right, we're great.
Oh, you know what? The numbers are not on there.
What do you mean?
It's okay. I know where I am. I'll know when it's my
turn.
Okay. Yeah, they're not numbered.
Okay.
So, all right, let me stop sharing for the moment.
Yeah.
So that we can, give me a second,
Okay.
Catherine, and I'll see if I can do that.
And okay, your little IP thing was on the bottom there too of the other one. So
I'm going to let Deb Meadows in because she works for you. So I figured that's okay to let her in right now. And then I'll wait for 4 o'clock to let everybody else in.
Awesome.
Then this way we get all this. That's why I wanted to meet a couple of minutes because this is my first time actually doing something like this. I've done Zoom meetings. We did a business after 5 Zoom meeting last week, and that was a little bit different, but having slides and everything, it's like, okay, I don't know.
I know the first time I did one too, I was but I do them a lot now. So
oh, yeah. I've been to so many. It's just now I'm on the other end of it. So
right.
All right, so let me have a look.
What a nice day. It was cool, but it's lovely now.
Yes. Oh, I meant to go grab my water. I'll be right back.
I'm going to grab mine too. That was key.
When you come back,
I'm coming back.
all right, when you come back, you'll see the slides and you can see, should see numbers. They are on there. All right.
Yeah? Yeah?
Hello?
It's Deb.
Hi, how are you?
Good. How are you guys doing?
Hi, Deb.
Good.
Hi, Catherine.
Oh,
Hi.
that's good, Lance. That's better.
You see it?
Yep.
I mean, I can try and make it a little bit bigger, but.
Oh, no, that's perfect.
That's okay.
Deb, are you going to let us see you or are you incognito?
No, I think I should, you should be able to see me.
No,
I don't think your camera's on.
Oh. Oh, okay. Here we go.
Bottom of the screen at the left. Oh,
Okay.
there we are.
Here I am. My skunky hairdo and all. How you doing, Lance?
Oh, I'm doing fantastic.
Oh,
Fantastic.
fantastic. Well,
Okay.
it's a beautiful day, so
It is. It's a lovely day.
yeah.
Actually, in the middle of it, wasn't able to walk the dog this morning, so I thought, I just got to a point of frustration with work that about 20 after 1, I decided to walk the dog.
Perfect.
So,
That's what
I
you
do
gotta-
that. I usually go out with them at like 7 in the morning, and then I usually go out after lunch. I think that's good for us.
Oh, yeah.
Yeah.
Oh,
it's better than yelling at somebody.
That's
that's true.
Kim, that's what you need to do. You and Jamie need to get a dog.
Oh, no, we're doing enough going out. Wait, like last night I wasn't feeling well. He actually rode his bike down to Burgess Park and back.
Oh, do you?
wow.
Yep. So we're doing a lot of walking, and now we're going to start bike riding. So
Oh, excellent.
it's been good that way. So
Well, it's
anyway.
nice down there.
Okay, we'll let Rick in. So we're good to go, and I can let some people in. You know, the only thing I don't know is how to mute everybody.
It's usually muted when you come on and then you unmute, but I'm not sure about the muting.
Well, Zoom etiquette, people should know. They're supposed
Yeah,
to, or you can
yeah.
make an announcement too, if
Yeah.
you want
Yeah.
them to.
Yep, I will do that. Okay. All right.
Yeah,
We'll let Rick in. It's still early. We've got 9 minutes, so we've got this all set up, so we're good.
Will anyone be monitoring the group chat box?
I will do that.
Okay, so I can close that part of my screen.
Yes, I can do that because what I'm going to ask the people to do is type their questions into the chat window, and I'll ask the questions from there because that usually works better than trying to get everybody to try and talk all at once. So anyway,
That's good.
all right.
Did people send any question in advance, Kim?
A couple.
Okay.
So is Rick trying to come in?
What's up with you there, Lance?
That's my still version. When I don't feel like people looking at me, you can look at just a cardboard cutout.
Is that your lawyer look? Or?
Yeah. It's kind of, I would describe it as pensive, I think. All right. I think
Okay.
Rick is in.
Yeah.
He's in. He's got his video off, but he doesn't show that his mic is off. But Rick, can you hear us? Hopefully he's working. It's working. His picture's up there, so it looks like it. Oh, maybe wait. Let me just double check. Nope. Oh,
Maybe he left the room for a moment.
All right. He did. Now he's back in the waiting room. I don't know. That's weird.
No, he might be having technology or data issues. That seems to be a common problem, people getting booted and then rejoining and booted and rejoining.
Lance, I'm going to make you a co-host too, okay?
Okay.
Make host. Oh, no, can't do that. That means you're going to be the host of the whole thing. I can't do that.
Okay, that's fine.
All right. All right, we have 2 more people joining. I have one person who said they're going to be late, so
Okay.
I said I'll try and remember to watch the participants window.
I was on a call this morning and there was a realtor on the call and he said they were worried that real estate was going to bottom out, but they had 65 new listings in St. Thomas and Central Elgin yesterday.
Oh my goodness.
That's a lot.
Yes.
It is, because I heard that it was not doing well.
Yeah. But maybe that's because we're here by the water, or I'm not sure. Could be.
Rick must be having issues because it still says he's joining.
Yeah, he doesn't show up in the participant list, which, oh, hold on.
There he is.
There he is.
But he's not showing as having, he shows as no video. Oh, hold
Oh,
on.
there's his
Hold on.
microphone.
Is he going to get audio?
Mhm.
Is he going to turn on his mic?
I have to unmute him first.
Okay.
There he is.
Nope, he's got it turned off, so, okay. That's good. Carol, you can hear us, and I assume you have your mic on by the looks of it.
Yes, I can hear you. Hello.
Okay, good. Hello.
Hi, Carol.
Hello, honey.
We still have six more minutes to go, so we think we're set up.
Kim, are there the other board members attending?
I don't know. I don't think so. Not that I know of off the top of my head.
Oh, there's Rick. Hi, Rick.
There we go. I'm muted. Hello.
Oh, hello. Good. Once it gets started, we'll get everybody to mute, but we've got 5 more minutes yet before we start, and then we'll go from there. So good to see you. Did you have a little trouble getting in?
Who, me?
Yes.
Yes. Well, it's just my computer. I know I've had to, with my council meetings that I've had here in Ingersoll as well, and other meetings that I've had on Zoom, I've had to attempt the 2 times and before I actually get brought in. So it's something I'm used to.
Got you. I'm sorry I don't have any beautiful music to play in the meantime.
I didn't think about that. I could have done that too.
I could play some rock and roll on my Spotify.
I'm doing some executive coaching, and he calls me every afternoon around 3. It's the end of his work day, and he knows. I said, now that we've finished our modules, we can chat every day, and yep, no problem. And I'm sitting on the couch listening to him, and the dog is barking and snoring in his sleep. Ruff, ruff, ruff. Life working from home.
I was on a Zoom meeting yesterday, and I was on a Zoom meeting yesterday, and the host actually had to give their dog a couple of treats because she knew that once she sits in that spot and she has her computer on, the dog starts yipping at her. So, well, let's just get ahead of that.
They're smart.
Mm-hmm.
They know they have a captive audience.
Absolutely.
Yeah, my cat does the same thing. As soon as she sees me on this computer, she has to jump right in there and walk all over the computer.
Yes. Wonderful pets and kids.
Oh, who put the music on?
Must have been Lance.
Oh,
Was it
Thanks,
Lance? No?
No, it's not me.
Oh.
maybe it's Catherine. I don't know. She's muted herself though, so it can't be.
Oh,
No.
maybe it was Carol. Oh, here comes people.
Coming in fast and furious.
Yes. Oh, there it is, right down at the bottom. I found the mute all button. It's on the participants. I'm looking for it on the bottom dashboard. It's not there. I haven't done very many Zoom meetings, so this is really my first one. Oh, we've got 10 participants in the meeting. Nope, one more coming in.
So I see that we've got a lot of Ingersoll folks.
Well, and it's interesting because we're sharing the Southwest Oxford one, Southwestern Public Health with Ingersoll, not this one. So yeah, but this is good. This
Yeah,
is okay.
that's great. I see a lot of familiar names.
Somebody definitely has the radio on.
Probably one of the non-video participants.
Mm-hmm. We've got another minute yet, so we'll get started. I think we should probably get started right at 4 o'clock, and then I'll let people in if we have to. So we'll kind of go from there. We've got another minute. Give people another minute, and then we'll go. Yeah, we've got some people that aren't in yet that I know have signed up.
And what is that behind you on the couch?
It's my friend. It's a puppet.
Oh, I wondered what it looks like, something like that, but I didn't know.
It's a puppet. I got it at Patina's in Ingersoll.
Oh, cute. Okay.
This is my friend over COVID.
Okay, cute.
So if I want somebody to talk to, it's either this guy or the cat. I have so much fun with that if I take it and put it in my car and go for a drive. People just think I'm losing my mind.
Okay, I'm going to mute everybody. And I am going to, where are you guys? Unmute, unmute, okay. All right, there we go. That was a little late. We've got somebody else joining, but maybe we'll start with the introductions, and hopefully the people joining will get to us, because it's 4:01 and I don't want to keep everybody too late. Everybody can hear me okay?
Yes.
Okay. All right. So I want to welcome you all to the COVID-19 HR and Employment Law webinar. We know you have many questions about returning to work, your rights as employers, if there's any new HR policies you have to put in place, and best practices. And I really want to thank Catherine and Lance, Catherine Ingledur and Lance Caesar for taking the time out of their busy schedules to put this on for us. I would like you, if you have a question, to leave it till the end, and please type it in the chat window that's down at the bottom, and I'll ask our experts at the end of their presentation. If I'll ask them the question, and if you prefer to send a question in the chat window privately, you could send it privately to me, and then that way not everybody will see who it is. So Catherine Englander holds a BA in French and Psychology, a certificate in Human Resources Management, and an HR Business Partner certificate. She has over 30 years in HR experience and has been teaching at Fanshawe part-time for 12 years. She's a member of the Human Resources Professional Association, as well as several members of the Chamber of Commerce. That I can attest to. Catherine is the founder and president of HR Partners for Business, Inc., a successful full-service HR firm serving Ontario, based out of St. Thomas. She's a member of the Woodstock Chamber of Commerce. Catherine and her staff offer HR services, including recruiting, workplace harassment investigation, policy and handbook development, assistance with layoffs, dismissals, and outplacement counseling while complying with employment law. Oh my. Lance Caesar is a two-time Western graduate. He has a BA in English and his law degree, and also a master's degree in English. And while at Western, Lance obtained a certificate in mediation from the Dispute Resolution Center and was the gold medalist in his law school class. He also completed the intensive trial advocacy workshop at Osgoode Hall in 2008. Lance has published several papers on a variety of labor and employment law topics and has spoken at the Law Society and many human resources events. And he also offers regular and employment law updates on LinkedIn, so you want to find him on LinkedIn. Lance has been practicing labor and employment law for 17 years and has opened his own labor employment law practice, Caesar Work Council, in March 2014. He advises and represents employers in virtually all sectors, including developmental services, municipalities, manufacturers, technology companies, transportation businesses, and professional firms. So thank you for attending, and I will turn it over to our hosts. So I'm not sure who's going first.
Catherine, you're up.
Are
I
you?
think Catherine must be muted. No?
Well, let's just get started with the presentation. You all set, Lance? There we go. So Lance has put together this presentation for us, and he will be starting.
Oh, I won't. Will I? Oh, I guess I will. Okay. I will pause here for a moment. Just so that no one thinks that I'm providing legal advice. I'm not providing legal advice. I'm providing legal information, but not advice. So this is a roadmap of what we're going to try and cover in the next hour. When can you legally restart or reopen? What are the rules surrounding when it's permissible? Health and safety measures that you should have in place, taking every precaution reasonable in the circumstances as required under the Occupational Health and Safety Act. We're going to talk about declared emergency infectious disease emergency leave. In particular, I'm going to bring up a couple of things that have arisen in the last few days in relation to the new regulation that was implemented by the government late last week. We'll also talk about work refusals and the duty to accommodate, how to deal with people who are reluctant to return to work or who are reluctant to do certain things in the workplace once you have reopened. We'll talk about layoff, recall, and deemed termination. And again, the new regulation that was implemented late last week has changed the rules significantly. So we'll spend a little bit of time talking about that regulation. It's not dealt with in the slides, but I will speak to that issue. And then we're going to talk about sort of soft issues like policies, procedures. What are the practices in your workplace that may have to be adjusted in order to be mindful of the considerations that are at play once you reopen or restart your business? So under the Emergency Management and Civil Protection Act, the province does have the ability to declare an emergency in order to enact orders to address crises like the current pandemic, natural disasters. An emergency was declared when SARS was an issue in 2003, for example. So an emergency was declared by the government on March 17th, as I'm sure you'll remember, about a week before kids were off for March break. And that really closed a number of areas of the economy immediately, left a number of essential businesses untouched. It was a bit of a joke. The initial order was very broad in the exceptions for essential businesses that it created. Subsequently, that list was revised on April 3rd. And that really was to narrow it down to things that were truly, to leave open only those things that were truly essential. Effective May 19th, however, the government launched phase 1 of the reopening. We saw a marked improvement in the infection rates and death numbers. And as a result, the economy started to reopen on a very, very loose timeline, which really doesn't contain any dates. So effective May 16th, golf courses were allowed to open with clubhouses open for washrooms and restaurants open only for takeout. Marinas, boat clubs, public boat launches are open for recreational use. Private parks and campgrounds are able to open and in order to prepare for the season and to allow access so that people who have to move their trailers and their vehicles on have the opportunity to do so. And then businesses that board animals. I know this was a big issue on Facebook. There were a lot of people lobbying to have grooming services made available again, but things like stables are also now open to allow boarders to visit and care for their animals. May 19th saw another broader wave of reopening. So retail services that are not in shopping malls. So if you have a street entry, you had the right to reopen. Limiting, as long as you were doing physical distancing, limiting the number of customers in the store. If you could have customers attend by appointment, those are the sorts of things that were requirements of being allowed to open. And you'll find that with a number of these permitted businesses that are reopening, there are a number of requirements attached to that permission. So seasonal businesses and recreational activities for individuals or single competitors. Again, this is in the belief, I guess, that you can play some sports without the necessity of being in close proximity or having contact with other participants. So things like tennis, track and field, horse racing. I've seen some people question tennis. You know, it's not as if a tennis ball isn't going to be in contact with your hand and you're going to be sharing that ball with the other person. But I think they've determined that that is of a, you know, not a substantial risk. So that's going to be permitted. Animal services, pet care services, grooming, training, veterinary appointments, those things are now allowed to occur again. I know from the veterinarian that I use that it's still by appointment and it's still contactless, meaning you're not permitted to be on the premises with your animal. So I think that's probably going to continue for a while. Household services such as housekeeping, cooking, cleaning, maintenance, all of those things are allowed to continue as long as they follow public health guidelines. The limits on construction have been completely lifted. So for a while, it was limited only to projects that were already underway or projects that were related to essential services. That's no longer the case. So all construction has been reopened. And some health and medical services such as in-person counseling, in-person services in addition to virtual services delivered by health professionals, and scheduled surgeries are all going to be allowed to go ahead. However, all of those healthcare settings are subject to very, very stringent pre-specified conditions that are outlined in the timeline document. And so anyone who is offering those types of services needs to be aware that there are some very stringent requirements. In particular, I know that dental services and surgeries are subject to very, very tight controls. So what's next? The framework for reopening our province, which was released on April 27th, indicates that phase 2 will be allowed if easing restrictions is successful, meaning that there's a consistent decrease in cases, that untraceable cases and hospitalizations also decrease, that adequate capacity and resources are available in the healthcare system. So again, that means fewer people in hospital due to COVID-19, quicker contact with new cases, and enhanced testing and contact tracing. So you've seen over the last week a big ramp up in the amount of testing that's going on. This past weekend, we cracked the 20,000 mark finally. So I think as long as the numbers continue to go down, both in new cases, deaths, hospitalizations, and capacity within the healthcare system, then we will see phase 2. No one has yet suggested when that will be or when it will be announced. So if your business is not essential, so it was not part of that April 3rd declaration, or it's not one of the businesses that was allowed to reopen in phase 1, then the emergency declaration in order to close remains in effect. So for the time being, you're still in the planning stage. Failure to comply with a closure order can lead to fines of up to 10 million. That's for a corporation. It's probably not going to be that large a number, but if a business was opening repeatedly in contravention of the order, then they could expect to see increasingly large fines. Those fines also can be attached to officers and directors of a business. So for those people who are the directing mind of a business, important to bear in mind that the risk could be personal as well. When further loosening of restrictions occurs, it is critical to get advice. Find out whether your business actually falls into the category of businesses that's going to be allowed to reopen before you take any steps to actually open your business. I'm going to turn it over to Catherine at this point.
So health and safety precautions. Under Section 25(2)H of the Occupational Health and Safety Act, an employer has a positive obligation to take every precaution reasonable in the circumstances for the protection of a worker. So this is standard, as you know, in every workplace. In addition to specific requirements such as providing prescribed protective equipment. So when planning for the reopening of your business, consider the hazards presented by person-to-person contact or by individual contact with surfaces or objects that may be touched by others, and means by which that contact can be minimized or eliminated, which we're going to talk about. So any reopening plan should include how social physical distancing will be maintained. That's, you know, the signs on the floor, those types of things that you can use, both between 2 or more employees or between employees and others who are present in the workplace. As you know, the grocery stores have the lines, different stores have marks on the floor that say, stay this far apart. Which processes can be made contactless or contact minimal so that you don't have to hand somebody your debit machine. You can have it on a stick or you can have it outside of the plexiglass. Identify any processes or services that will be suspended temporarily or indefinitely because they're 2 people facing or contact facing. What measures can be applied to restrict the number of people working within areas, meeting room capacity limits, controls on customers entering, consider whether there are technological measures that can assist, and ensure adequate hand hygiene facilities are available, primarily for employees, but also for visitors to the workplace. I think everybody expects hand sanitizer in most places that you enter now. Okay, Lance? So any reopening plan should include, consider where physical barriers may be needed, such as around cash handling or customer service areas such as plexiglass. Consider reducing cash handling by requiring electronic payment, Interac and e-transfer. Consider making cloth masks a requirement for those entering the workplace if feasible, and source sufficient PPE for staff, masks, gloves, shields, whatever you need. Consider closing parts of the workplace to staff only, and implement sanitizing routines that ensure all routinely touched surfaces get regular cleaning with disinfecting products. Stay abreast of the guidance or any directives from public health authorities such as the Chief Medical Officer of Health or local health units. Review any applicable industry or sector-specific guidelines such as construction, food processing, restaurant, and food service from the Ministry of Labor and Training, Skills and Development. Also review general guidelines from the Ontario Government and Health and Safety Associations. And we've got a link there that you can see. Over to you, Lance.
That link actually contains, I think, over 90 directives and guidelines from various health and safety associations from the government, and they're very specific. They're specific to activities. They're specific to industries. So there's actually, I have to applaud the government. There is a wealth of material on that website, and I would strongly encourage you before you reopen to take a look, because there's stuff there that, you know, we can't possibly cover all of the precautions and measures you might want to put in place. So you're getting a range of advice there from different experts in the area.
So Lance, are you going to share the slides, or should we be copying?
Slides are absolutely going to be available once this is over.
Okay.
I've actually put in some notes on some of the slides, so I think it'll be important for people to have access to that.
Okay.
In particular, in relation to infectious disease emergency leave and temporary layoff under the ESA.
Okay.
So that stuff, this will all be available for you at the end. We'll work with Kim to make it distributed, get it distributed there. So in response to the pandemic, the government instituted this new infectious disease emergency leave by amending section 50.1 of the ESA. So 50.1 was declared emergency leave. Whenever there was a state of emergency, if employees were unable to attend work for a number of reasons because of that state of emergency, they were entitled to receive job protected statutory leave. So under the old declared emergency leave, if you were required to miss work because of a closure order, so at the beginning of the pandemic, when the initial order was made, if you were a non-essential business, you were subject to a closure order under the Emergency Management and Civil Protection Act. So that's one example. If you were closed or you were unable to work because of an order under the Health Protection and Promotion Act. So if your workplace had been had an outbreak, then there would be a closure order under the Health Promotion and Protection Act. That also would entitle you to leave. If you're an employee who has to provide care or assistance to a close family member, then that would also entitle you to leave. Or if you were absent from work for other prescribed reasons. there weren't any prescribed reasons instituted when the changes were made to section 50.1. However, that has changed. So I'm going to go to the next slide. This is the new leave that was introduced. So in addition to declared emergency leave, there's also infectious disease emergency leave, which was really meant to respond directly to the COVID-19 pandemic. So it's available under the following circumstances. And I'm going to make note of the prescribed reasons at the bottom because that's where the new regulation comes in. So if an employee is under medical investigation, supervision, or treatment for COVID-19, they would qualify. If they're acting in accordance with an order under the Health Protection and Promotion Act, so if, for example, they had been in contact with someone who was known to have COVID-19, then they might actually have an order made by the local officer of health saying that they are to self-isolate, that they're to quarantine, or that they themselves may very well have to be tested and might be positive. If the employee is already in quarantine or isolation, including self-isolation, I would point that out. So it doesn't have to be that they've been ordered isolated by a health authority. They may be following guidance from the public health authorities generally to self-isolate because of certain circumstances. And that means I would note that the words are information or directions from public health authorities. So it may be that you hear that people who have been exposed, who have bought bread at Superstore may have been in contact with someone with COVID-19. If the information received from the public health authority is that you should self-isolate, then self-isolating would qualify you for the leave in that case. If they've been directed to stay home by their employer because of a concern that they may expose others to COVID-19. So again, anything that looks like the person may pose a risk of having COVID-19 is going to qualify them for leave. If it, because of a matter related to COVID-19, such as daycare or school closures, they cannot come work because they're caring for a family member, that's going to qualify. Or if they cannot travel back to Ontario because of travel restrictions. So as you are probably aware, I think since April, there have been travel restrictions in place that may prevent some people from returning from other jurisdictions. Those people are also covered. What has happened more recently is the passage or the implementation of Regulation 228/20, which is the Infectious Disease Emergency Leave Regulation. That regulation has made some changes. So entitlement to infectious disease emergency leave under section 50.1 has now been expanded to include the reason that the employee's hours of work are temporarily reduced or eliminated by the employer for reasons related to the designated infectious disease. And in this case, the designated infectious disease is COVID-19. So if someone is not able to attend work because their employer has either reduced their hours or eliminated their hours of work, i.e. laid them off, that person is now eligible to take the declared emergency/infectious disease leave. The reason for that is going to become relevant when I talk about temporary layoffs. Essentially what's happening is someone who was laid off previously is not laid off anymore. They are now deemed to be on infectious disease emergency leave. What that means is that they've stopped the clock on the 13 weeks in 20 or the 35 weeks in 52 that would be a temporary layoff under the ESA, meaning that you now can't exceed a temporary layoff. You aren't deemed to have terminated your employees. Your employees are on a job protected leave. They're not on layoff anymore. So for anyone who has employees on layoff, that's the impact of this change that's been instituted by the regulation. And I will talk about it more detail when we get down to the temporary layoff section. So as long as the underlying conditions apply, for as long as the declared emergency or as long as COVID-19 is designated as an infectious disease, the employee is entitled to job protected leave. They do not have to give you a doctor's note. So if their doctor has suggested that they isolate, they don't need a note to that effect. And as with other statutory leaves, they are entitled to return to the position that they most recently held with the employer if it still exists, or to a comparable position if it does not, once the leave ends. there's going to probably be a lot of situations where the former position no longer exists when this is all over. So that will be something that employers will need to be aware of. Failure to observe that requirement to return the employee to their pre-leave position could comprise a reprisal under Section 74 of the Act. So if there's a situation where after COVID-19 has passed, you don't have the position available for that employee to return to, you may need to get some advice on what a comparable position is or what action you should take in those circumstances. Over to you, Catherine.
Yeah, so some employees may be reluctant to return to work or to perform aspects of their jobs. I've been getting calls like this from employers for a while. How to address that reluctance will depend on the circumstances. The right to refuse unsafe work is very serious and can't be exercised lightly by employees, nor can it be used merely to solve workplace problems. Likewise, the duty to accommodate employees will only arise where there are human rights considerations. So the right to refuse unsafe work. Work refusal is a process that must be followed in order to determine whether an employee can legitimately decline to perform particular work. It's a Ministry of Labor process or employment standards process. The worker must advise the employer that they believe the work is unsafe, giving reasons for their refusal. So that means a conversation between you and the employee. The employer may then have an obligation to advise other parties of the refusal, such as, for example, a health and safety rep, or a union rep, or a joint health and safety committee. So the right to refuse unsafe work continued. The refusing worker may be offered other work. The refused work may be offered to another worker, but management must inform the new worker that the offered work is the subject of a work refusal. This must be done in the presence of a member of the Joint Health and Safety Committee who represents workers, or a health and safety representative, or a worker who, because of his or her knowledge, experience, and training, is selected by the trade union that represents the worker, or there is not a trade union by the workers to represent them. So the employer must then examine the situation, determine whether the right to refuse unsafe work is justified, and advise the employee and any other required parties of its decisions and the reasons for it. So that's a conversation again between you and the employee refusing the work, where you're trying to determine how you can make it safer for the employee. While the employer is reviewing the circumstances, the worker is to remain somewhere safe in the workplace. At first stage, the employee need only have an honest belief that the work is unsafe. After the employer conducts its review, the issue may be resolved and the employee may resume working with or without adjustments to address the safety concern. If the worker does not accept that the issue is resolved, they have the option of escalating the issue to the second stage. So the right to, continuing on, at the second stage, if the employee has reasonable grounds to believe the work is unsafe, they may continue to refuse. If the employee continues to refuse the work, the Ministry of Labor should be contacted. A Ministry of Labor inspector investigates in consultation with the worker, health and safety reps, and management. The Ministry inspector determines whether the work presents any hazards and issues a written decision. If the work is not unsafe, the employee is directed to return to work. If the inspector makes any orders, the employer must comply before the worker or any other employee can be required to perform the work.
Just wanted to jump in for 1 second. So
Yep.
what I've heard from employers who have had work refusals during the COVID-19 pandemic is that, generally speaking, the ministry does not send anyone out physically to look at the workplace. They've been doing telephone inspections where they basically will organize a conference call and determine, based on the information that's provided by all of the parties, whether or not the employer has put in appropriate precautions in place to protect workers' health and safety. So, if you've got physical distancing and you've marked your floor and you've put signage up indicating that people are only there for essential reasons and that people need to wear masks, or whatever precautions you need. If you put plexiglass up for customer service windows and things, if the ministry, has a look at the various measures that are in place and thinks that what you've done is reasonable, they're probably not going to go any further with it. I know that there was a very big push initially among essential workers to push back on being in a workplace during the pandemic, and I know the ministry has not issued hardly any orders on those work refusals. So it's not something necessarily to be fearful of. It may very well be the thing that employees need in order to accept that it's safe for them to be at work. And I'll turn it back over to you, Catherine. Sorry for.
Yeah. Sorry. No problem. So last week I was on a call with the Tillsonburg Chamber. I was on a panel answering questions for the Tillsonburg Chamber, and there was a gentleman on the call who was the operations manager or CEO of a food manufacturer, and they had a work refusal. They were wearing the plexiglass masks, or the face shield, sorry, the plexiglass face shields, and they had a work refusal, and the Ministry of Labor advised them that their employees needed to wear a mask as well as the face shield. So that was their order. He was upset about it because to wear a mask all day like that is not comfortable. So in any case, he was considering challenging it. Anyway, some employees may have physical illnesses and disabilities or family-related issues that legitimately preclude them from returning to the workplace or from performing specific duties, direct customer service. When confronted with a request for accommodation, gather information, the reasons for not being able to return to work, other resources or supports the employee may be able to access, what adjustments may be required to permit a resumption of duties. Consider the ability to accommodate the request with alternative measures, such as working from home, alternative positions with less customer or coworker contact. Where the concern relates to the employee's own medical condition, seek documentation from their treating practitioner that addresses their ability to be at work and any required accommodations. Be prepared to accommodate with leave or workplace modifications. Where the concern relates to the health of an employee's family member, information about the nature of the concern can be requested, but medical documentation cannot. So you cannot ask for medical documentation in that case. Weigh the requested accommodation against operational requirements, but remember that the duty to accommodate is to the point of undue hardship, which is a very high threshold. In the absence of a legitimate, which is a human rights related reason to not return to work, be careful not to commit to accommodations. And on that note too, if you do an accommodation, make sure it has an end date. Lance taught me that a while back, even though I was doing it, but that came up at another meeting we were at. Fear of the virus is not an adequate reason unless it results from a psychosocial disability. If the reason relates to the unavailability of transportation due to disruption of transit services, for example, consider whether alternative arrangements can be put in place, such as ride sharing, to allow the employee to get to work. For employees who refuse to return without a legitimate reason, even after canvassing alternatives, determine whether to offer a leave or end the employment relationship.
And on that latter point, if it truly looks like this is the end of the road, just be careful. We haven't seen how the courts have reacted to employers treating fear of the virus as as a sort of an insubordination or an abandonment of one's job. So it's really yet to be seen what degree of compassion the courts will have or tribunals will have for people who refuse to come back to work simply because they don't think it's safe. So you probably should get some advice if you are thinking that you might have to end the relationship with someone who refuses to come back. So under the ESA, let's talk about layoff, recall, and deemed termination. And I'll be right up front. The rules have significantly changed with the enactment of Regulation 228. But under the ESA, there is a definition of temporary layoff that is accepted as being a period that you can lay someone off without their employment being deemed terminated. So in the normal course, that would be a layoff of up to 13 weeks in a 20-week period where you don't provide any compensation, benefits, pension accrual, etc. If, however, you provide compensation, benefits, pension RSP contributions, or subpayments, then the period of a temporary layoff is extended to up to 35 weeks in a 52-week period. Different rules apply under collective agreements. Collective agreements are subject to whatever period of recall is available to employees. So a temporary layoff under a collective agreement can be significantly longer. Now, before I go on to this, under the Reg 228, what has happened is essentially any layoff that occurred during the COVID-19 period. COVID-19 period being any layoff that occurred between March 1st of 2020 and 6 weeks after the declared emergency is terminated. That's the COVID-19 period. So anybody who is laid off during that time span and who has not been terminated during that time span is now considered to be not laid off. They are deemed to not be laid off. They are deemed to be on an infectious disease emergency leave. So if you had laid people off, this regulation came into effect on May 29th. The clock stopped. Whether that's the 13 weeks in 20 or the 35 weeks in 52, the clock stopped. Those people are now on an emergency leave under the ESA, and they are on it's a job protected leave, meaning that when the leave ends, they need to be brought back to work in the position they were in formerly. But it also means that the clock has stopped on that potential deemed termination. The reason the timing of the regulation is important is because people were laying off their employees starting in mid-March. By mid-June, we were going to hit the 13 weeks. So in order to avoid a massive wave of deemed terminations under the ESA, basically the government said, okay, they're not laid off anymore, they're on leave, and the clock has stopped. By my calculations, even if the economy were to reopen, if the declared emergency were lifted at the end of June, which is, I think, a possibility, but not a likelihood, then the COVID-19 period is going to run until mid-August, meaning that people will be considered to be on leave for that entire period. The clock will not be running on their temporary layoff during that time. If you can't return them to work by the time the COVID-19 period ends, you might have to put them back on layoff. But then it becomes a mathematical calculation of whether you have to count any of the prior period of layoff in figuring out whether they've exceeded a temporary layoff. Another thing that's important to understand, they also made a point in the regulation of deeming that a layoff or reduction in wages does not constitute a constructive dismissal. So you don't have a claim now for constructive dismissal based on a wage reduction or reduction in hours or a layoff. So that's important for employers, because I know that when people started to do layoffs initially, there was a lot of concern that there'd be a wave of constructive dismissal claims. It didn't happen, but now it's basically foreclosed from happening. One further thing that you need to know, any claims for termination and severance based on deemed termination are now wiped out. So if anyone had made a claim to the Ministry of Labor that they were constructively dismissed, or that the layoff had become a deemed termination under the Act, those claims are all wiped out. Those complaints are as if they were never made. So for employers, I think this is welcome relief. It means that you now have some time to breathe. You have some time to plan. You have an opportunity to move forward with your business without the fear of a massive severance cost hanging over your head. That being said, I'm going to walk you through some other things that you need to consider with respect to those employees who were laid off and who are now on leave. I think a lot of this advice still is applicable, particularly since we don't know whether employers are going to be in a position to return employees to work immediately upon the end of the COVID-19 period. So employees who are placed on layoff should be given written notice. If you didn't do it, it's probably not an issue now. However, again, if the leave turns back into a layoff at some later date, providing written notice of layoff would be appropriate. As a matter of best practice, you should provide employees with at least a week of notice of recall once a return to work is feasible. That gives people an opportunity to try and figure out their home life, make some personal decisions. We don't know, again, when childcare will be widely available, given that there are no overnight camps. There will be some day camps operating this summer, but otherwise we don't know when larger childcare centers will be open to provide those services. So people may need some time to make adjustments in their life in order to facilitate a return to work. Important to understand, recall of employees is not tied to length of service. There is no concept of seniority outside the unionized setting. Under a collective agreement, you may very well be required to take back the most senior people laid off before you bring back more junior employees. That's not the case with a layoff at common law. If you need only certain areas of your operation to restart, if you only need people with certain skill sets, you're going to bring people back in the order that's appropriate for your operational requirements. And ultimately, if we end up with people being placed back on layoff at some point in the future, again, careful to watch the clock in terms of how much layoff time has accrued based on whichever period is appropriate, whether it's the 20 weeks or the 52 weeks, because you may yet end up in a situation where some of those layoffs will trigger a termination. There was a risk of constructive dismissal claims at common law. It's not clear whether the regulation only foreclosed constructive dismissal claims under the ESA, or whether it also closes off the possibility to claim constructive dismissal at common law. I think that's something that we're probably going to get some clarification from the Ministry of Labor on over the next week or so. But it may very well take a claim in the courts before we find out. I'm going to skip the rest because, again, I don't think constructive dismissal is going to be a significant risk in the near future, given the institution of that new regulation. Turn it over to you, Catherine.
So adjusting workplace practices to reflect the new normal. As part of the planning for resumption of operations, considering the following items that will establish the baseline for your operations going forward. Schedules. Are existing work schedules appropriate, or should you have staggered start times to reduce the number of staff on the premises at any given time? Staggered lunches, staggered breaks, so that people aren't forced to be closer than they want to be. Work locations. Will some employees be allowed to work from home more regularly? There are a lot of places that are looking at that now. If so, what other changes might you make? Hoteling space and offices, changed locations, terms in employment agreements, reduced real estate needs, etc. Training. Review training on customer service and personal interactions, respectful workplace training to determine whether updates are in order. Ensure staff understand the rules of the new workplace sanitizing, the workplace policies, employment agreements. We offer training through my company. Lance probably does too if you need some training. As part of the planning for resumption of operations, consider the following items that will establish the baseline for your operations going forward. Sanitizing the workplace. Who will do it? In-house or contracted? How often and what areas? If it will become part of the expectations for staff, consider including it in job descriptions and policies. Workplace policies. Look at policies on leaves of absence, time away from work. In case of a second wave, how will absences be treated? Review respectful workplace and other conduct policies. If work from home will be common, draft policies and review, update social media and appropriate use policies. Employment agreements. Consider whether work from home ought to be expressly spelled out. If it's likely to become a regular aspect of the job, address any changes to leaves of absence. Reserve the right to lay employees off temporarily. Are there any questions? Kim, you're muted.
I muted myself so I wouldn't make any noise. I don't have any questions in the chat window at this point in time. Does anybody have a question they want to type in, or would you prefer to, if I unmute you, ask a question?
I actually have a question if I can step in.
Sure.
So I'm currently working. I've got all my staff working from home. I gave them 2 weeks notice that we were going from part-time up to full-time. And we are now working full-time from home, except for a couple of my staff who say that they can't because of childcare. At the same time, a number of weeks ago when I let everybody know we were going to full-time, I gave them all notice that we're going to be back in the office July 6th. And a couple of them are saying that they can't, again, because of childcare. Now, I know Doug Ford allowed babysitters and nannies in the home. How is that not relevant in terms of childcare?
You still need to find somebody who's willing to do it. So just the fact that people are permitted to do it doesn't mean that someone necessarily has those arrangements in place.
If I find somebody for them, would that then?
You're not going to be able to dictate to somebody who's going to come into their home.
Right.
I'm pretty sure you wouldn't allow someone to dictate to you who's going to come into your home and care for your children.
Right.
So it's not going to be something you can mandate.
So when they say that they want to continue working from home, how do I deal with that when it's obviously if I let them, then everybody's going to want to do that. And getting things back to normal, you know.
Okay, what's your business?
Yeah.
I do architectural work.
Okay. So I think you would have to make a very strong case for what is it in the office that you need to get done that can't be done from home.
Right.
I mean, you're going to have to accommodate people's need to provide care for their children. If they don't have childcare in place, they are entitled to be on a leave rather than working. So if you've got, I mean, it's really a question of what's better, having them on leave and not working at all, or having them working from home.
Right.
Because realistically, until childcare facilities are broadly open, it's not going to be an option. People are not going to be able to find somebody that they trust enough to have them come into their home and care for their kids.
And the other point that, and I don't know how easily you can measure productivity, but if you can measure productivity in that employee between the hours of 6 a.m. and midnight or 2 a.m. to produce the amount of work that you generally would require, then in my opinion, they're doing the best that they can. Now, I realize that if they can't be productive, then we've definitely got an issue. I agree with you.
Right. Now, when I've given them the flexibility to work from home and they don't want to work full-time hours, is that something that I can, like, because I need them working full-time hours.
You've got full-time work.
Yeah. And I've let them know that I'm flexible with whatever hours they want to work. If they want to work 4 hours in the morning, 4 hours in the evening, and some hours on the weekends, but they're adamant that they will work from like 7 a.m. to 1 p.m., pretty much 6 hours a day, 5 days a week, which I'm happy with that they're doing something, but I just need full time from them, right? Like.
And so you've had the conversation about childcare.
Yes.
And the individual is not interested in bringing in childcare.
Correct.
Okay.
And, you know I've been flexible and I've provided flexible options. And when I say, just get your hours in for the week, it's no, I want to work these hours. How do I deal with that?
Are they reporting the actual hours that they're working?
Yes.
Okay. So you're not paying them for time they're not working.
What's that? Sorry?
You're not paying them for time that they are not working.
Correct.
Okay. I'm going to say this is unprecedented, but I don't think the Human Rights Tribunal is going to be on your side if you decide to take action.
Right.
Just going to say, not undue hardship. This is a family status accommodation issue writ large. They're going to have, if you decide that they're not getting enough done, if it's a question of them not getting enough done, then it's a performance management issue.
That's what I was thinking.
So that's something separate. If you are hired for a full-time position and you've been given the option to work from home rather than come into the office to accommodate your childcare needs, and you're not able to meet the requirements of the job, then it's a performance management issue, and you're going to have to start to apply pressure that more work needs to be done. If, however, you are getting an adequate amount accomplished, not ideal, but adequate, that's going to be a pretty tough road to hoe until there's actual, available childcare so they can be in the office where you can keep an eye on them and where the work gets done.
Okay. Yeah.
I was thinking it's a performance management issue as well, except that we're in such a gray time because, I can see it both ways, but I would also probably start to apply a little bit of pressure to see if we couldn't get a babysitter.
Yeah.
Somehow.
Yeah. Okay.
I think it's probably a conversation at this point with the employee to say, okay, this has been acceptable, but we really need more. The business is ramping up. We expect to have more demand for our services, and 30 hours a week ain't gonna cut it.
Right.
So let's have a conversation, because this is not negotiable at some point. I don't want to be a bully, but I need 8 hours from you. I need 40 hours from you over the week.
Right.
How are you going to provide it? Figure it out, and make it a conversation. But this, I'm only going to work these hours. No, that's ultimately you're probably. What's the difference between 7 and 1 and 7 and 3?
Right.
There's really not much there. So
right.
Unless they've got some compelling reason why between the hours of 1 and 3 they can't work,
well,
we're going to want to start applying pressure.
And that's what I've done. And their compelling issue is their children. And my rebuttal was, so spend some time on weekends when your spouse is home and can care for the children.
Or in the evening, or I think that you are suggesting reasonable options. What you might want to suggest is that if it persists long term, we may have to look at, recalibrating your hours permanently. Do you really want this to turn into a part-time job?
Yeah.
Okay. I don't think you want to go down that road, but I think you need to let them understand we need more work done.
Right.
Again, you're going to have to be able to justify that. You're going to have to be able to show that there's some shortcomings and that other people are being required to pick up work that belongs to an employee who's only working 30 hours a week. But I think if you start having the conversation and maybe be a little more, impress a little bit harder, hopefully you can come to a compromise.
Okay. Perfect. Thank you.
Anybody else?
Everybody wants to stay quiet on their employees.
That's why I offered you could actually
Send them privately.
privately chat me, but nobody's privately chatted me. So,
Our contact information is also on the slide presentation. So if you did have a question outside of this forum, you can contact us.
and you'll send me the slides, correct?
Lance will.
Yeah, yes. Perfect. And
I
then
have a question.
okay.
So I did submit it yesterday, but I guess, or the other day when I registered, but whatever. I had an employee right from day one when this pandemic or the emergency was called. You know, we sat down, we had a meeting, we told them the symptoms, how we're going to proceed. The very next day, he called in sick with 90% of the symptoms of COVID. We are an essential service. We do emergency services for insurance companies. And he has refused to this day to come back to work. Absolutely stated until his CERB runs out, he won't be back. I'm not too sure what to do. I had to hire someone else to cover him. So technically, at this point, his position is gone. Do I need to take him back? Can I terminate his employment?
Lance, do you want to speak to that? You're muted.
I am, for good reason.
Oh,
Well, okay, I'm going to say right now, I'm not going to answer that question because it's far too specific, and I'm not giving legal advice because I'd be held accountable for that legal advice, and I don't know enough about your operation or the employee. What I can say is an employee has a right to job protected leave under section 50.1 sub B or sub 1B in a number of specific sets of circumstances. If an employee does not qualify for one of those sets of circumstances, they're not under investigation for COVID, they're not self-isolating for COVID, they're not, and it has to be self-isolation based on information or directions of public health authorities. If they're not staying home because the employer has expressed a concern that they may expose others, if they're not caring for a family member because of an issue with childcare or daycare closures, if they're not out of the province and unable to return to Ontario, then they don't qualify for the infectious disease leave. If you are an essential business and you have a right to be open, if you have taken appropriate measures and precautions so that your Occupational Health and Safety Act obligations are met, if there is no human rights issue, they don't have a disability, they don't have some sort of family status obligation that precludes them from working. If it's just, I don't want to work, then that might be a job abandonment, and it might be something that the employee could be, viewed as having resigned for, but you would need to get some advice on that.
okay.
Okay?
Yeah.
I mean, we're talking about the end of an employment relationship. That could involve significant risk to you and your organization. And I'm not giving advice on it for free because it could pose then significant risk to me. But it is a situation where I would highly recommend getting some advice because it does sound like a situation where you would have at least an arguable case to take some action, whether that's putting the employee on a final warning that if they don't attend work on a certain date, that their employment's over, or whether that's just outright treating them as having abandoned their job. I think you will have to take some action because it doesn't sound like the person's going to come back voluntarily.
Okay.
Okay?
Yep. I think you kind of answered the question for me.
Well, I probably kind of did, but I didn't really.
Yeah. No, I got it.
Okay.
You did very well at not answering that question. Does anybody else have a question? Everybody's shy.
I think everybody wants to wait for the slides and see.
Yes. So if you email me the slides, I'll make sure everybody gets the slides. I also, if you want, I can send a recording of this presentation to you as well. So you can go back and listen to it if you want. I want to thank, once again, I want to thank Catherine and Lance for putting this on for us. And just a reminder that we have another webinar coming up on Thursday with the Southwestern Ontario Public Health. It's at 2 o'clock. Registration is free. So if you have some questions about specific health things you need for your workplace, and then we have one on stress in the workplace Monday at 3:30. So you can look on our website to sign up for those. So thank you everyone for attending. We're just under an hour, so that was good. And I appreciate your time. And I hope this was helpful. Thanks everyone.
Thank you.
Thank you.